Kababayan to live and thrive here in the U.S. And you can't do that unless the first thing that you need to figure out is your documentation here in the U.S. And every other Wednesday, we give you updates on immigration.
This American Dream segment is brought to you by Aquino & Lowe Law Firm, answering your immigration questions.
Attorney Richard Lowe is joining us this afternoon to talk about a very complicated matter. But first, the simple one. F2A category, what is that? And I hear that it's still current.
Well, F2A is the category that is beneficiaries of a petition filed by a husband or for a minor child. So if you're a legal permanent resident, you can file a petition for your spouse and your minor child, and that visa category is current right now and will be through the end of September.
Meaning if I get married and I file for somebody who needs paper, he gets his...
Possibly, but you still have to be in status, or you have to have...
He has to be in status.
Yes, the beneficiary still has to be in status unless they're 245I eligible.
Which is 245I, it's something that has something to do with a case that we're going to be discussing today, which is not simple, so take a listen. Case name, matter of Estrada, BIA 230... Do I have to mention all this? Okay, facts of the case. Filipino man and woman came to the U.S. in the late 1990s, married in 2007. Wife is a beneficiary of an I-140 petition for alien worker filed on April 9, 2001 as an extraordinary ability alien. The petition was then withdrawn in February 2002. I didn't know that you could withdraw a petition.
Yes, you can. And in this case, it's obvious that what was trying to happen here, she was trying to qualify for benefits under 245I, and so filed a petition as an extraordinary ability alien in which you don't need an employer.
You don't need an employer, yes.
In order to try to qualify.
Right.
Not being able to meet those qualifications, she then later withdrew the petition, thinking that it would have no impact on whether she was 245I eligible.
Okay, the petition was then withdrawn in February 2002. Wife was the beneficiary of another I-140 petition filed in 2006, which was subsequently approved. Now, you can file multiple petitions.
Yes, it's not a problem to file multiple petitions, and in this case, this is what she did. She probably went out and found an employer at that point in 2006 who would sponsor her and went through the process, imagining that she could use the previously filed petition in 2001 to grandfather her into 245I.
But this is the danger here. When you file many petitions, that could be expensive.
Yeah, it could be expensive. And really, it's important to know that you just can't file anything and expect it to give you a benefit. You have to be careful about what you're doing so that you're using your resources wisely and you're not needlessly putting petitions out there that aren't really going to do any benefit to you.
All right. Now, it gets more complicated. Husband, so the husband, the Filipino man, was the beneficiary of an approved I-130 petition for alien relative filed in November 2000 by his ex-wife. So there's a third person involved, the ex-wife. Now, man and woman, minus the ex-wife, obviously, both seek to adjust their status through the wife's second petition. This seems a little complicated.
Yeah, it is. But really what you're going to take out of this is the fact that, first of all, 245I is not dead. Even though it's 12 years old, it's still around and it's still useful. But in this case, you also have to remember that the person that is getting the benefit has to be the person that's qualified for 245I. And this is what this case was really highlighting here.
Okay. 245I, what is this, very briefly?
That allows you to pay a fine if you are an overstay or if you entered the United States illegally. It allows you to pay a fine and adjust your status here so you don't have to go home. As we were talking in these F2A categories, if you're a legal permanent resident, you marry somebody who does not have, is not in status, if they are 245I eligible, then they can adjust their status here without having to go home.
Which begs the question, who is 245I eligible?
Well, the important date for 245I and what the court was pointing out is April 30th, 2001, because that is when the law sunset. So you need a petition that was filed prior to that time, and not only that, you need the relationship to have occurred prior to that time. In this case, the husband and wife married after 2001. And so there was that issue of whether or not he, being 245 eligible, could give benefits to her. But the court said no. If it's after acquired, then you can only get benefits through 245I if you are following to join or accompanying the principal who is 245I eligible.
Okay. Now, if you were hoping to be in this situation where the effect on you is positive and Attorney Richard Lowe just crushed your hopes, don't worry, because there are many avenues that may be available to you. All you need to do is consult a lawyer because they know better. Remember, filing different petitions, you can avoid that by getting the best advice possible right from the onset. And Attorney Richard Lowe and Attorney Allison Aquino of Aquino and Lowe are always there to give you that information on the screen to schedule your one-on-one appointment. Thank you so much, and more power to you.
Thank you.
Entertainment when we return on the show. Don't go away.